Hello and welcome to my channel Happy Hours. In my last video, I discussed about the social audit, challenges faced by social audit, and some suggestion to solve this issue. In this video, I am going to discuss about the RTI, which means the right to information, about its objectives, history, and about the features of the RTI. So what are we waiting for? Let's jump to the first topic, which is the right to information. It is another tool of social accountability. Objective is to bring transparency, policy monitoring and policy evaluation, to avoid arbitrary decisions of the government, and to increase the incentive proactive participation of citizens, which is going to lead to get good governance and to improve the social capital. In summary, we can say RTI has a twin objective of ensuring first the good governance, which implicitly ensure the accountability, transparency, responsiveness, participation, efficiency, rule of law. The rule of law is there, it means there will be no arbitrary decisions. Now the second one is the insurance of social accountability. It is going to improve social capital, legitimacy of the government will also be improved, and more democratic or the participative administration will be there. Now the citizens are going to get a tool for more accountability from the government. Now let us understand about the history of the RTI. First country to enact RTI as a law was Sweden in the year 1766. In Finland, Denmark, it was adopted in the year 1960s. New Zealand adopted in early 2000, and that was the same for US and UK. They adopted the law in 2002. India has first adopted the law in 2002 when it was known as the Freedom of Information Act. Then later they passed a law in 2005. But in the year 1990, the VP Singh became the first Prime Minister to advocate a law that was the RTI law. In the year 1994, a grassroots organization called as MKSS, which stands for Mazdoor Kisan Shakti Sangathan, started a movement in Rajasthan to demand a right to Information Act. In the year 1996, a national campaign for people right RTI was established, where different NGOs came together to start a nationwide campaign. In the year 1997, Tamil Nadu became the first state to enact the RTI law. In the year 2002, the NDA government passed the Freedom of Information Act, which was never implemented. Finally, in the year 2005, UPA government enacted a new law called the RTI Act. Now, we should understand what was the administration before the year 2005. The administration had the law, which was the Official Secret Law or Secret Act 1923. So we can understand from the pre-independence, after independence, and even till 2005, this Official Secret Act was followed. Means they were officially never giving the secret to the citizen, or there were no right of information to the people. There were multiple cases when the Supreme Court had ruled that the RTI was an implicit right under the Article number 19, Clause 1, Subclause A. From the year 1970s, they were saying this. But the law came in the year 2005. Before 2005, RTI lacked one more thing, and that was the institutionalization. Now let us understand the next thing, and that is the feature of the RTI. The law provides the RTI is to seek information against a public authority. Now we should understand what is a public authority. A public authority includes anybody constituted, first under the Constitution, second by the law of Parliament or state legislatures, it is the statutory bodies, and third is by a notification issued or an order made by an appropriate government, where an institution is declared as a public authority provided it is substantially financed by the government. So two condition is to be followed. First, that institution should have the financially substantially financed by the government, and secondly, it should be notified by the appropriate government. We can understand this by an example. The Jammu and Kashmir Bank, the capital initially was provided by the government of the Jammu and Kashmir. However, it was not notified as the public authority. It is done by the year 2017 by the governor of the Jammu and Kashmir, and he authorized that it is a public authority. And by that time, the Jammu and Kashmir was a state. Before that time, we could say that we cannot file an RTI against the Jammu and Kashmir Bank. But after the year 2017, we can do so. Another example is NGO, which is substantially financed by the government funds. The RTI law exempts political parties and the judiciary from the purview of RTI. That is, we cannot file for RTI against the judiciary or against political parties. In the year 2013, the Parliament passed an amendment to RTI exempting the political parties. The judiciary was never made a part of RTI law. However, the Delhi High Court has ruled that the office of Chief Justice of India falls in the purview of the RTI, and decision was taken by the judiciary. The second feature of RTI is that what is the definition of RTI to information, or we can say the right to information. First is to inspection of work, documents and records. Secondly, taking notes, certified copy of documents or records. Thirdly, taking certified samples of material. And the last one is obtaining information stored in electronic format. So these are going to be given by the government when there is a ask for right to information. Now the third feature is that the disposal of requests. The law mentions that information will be provided within 30 days of receipt of the request. If the information concerns life and liberty of a person, it would be provided within 48 hours of the request. If the information has been rejected, then it would also be informed the reason behind it, the period in which the appeal can be made, and the appellate authority where we can appeal or where the appeal can be made is also mentioned. 30 days time period is not mentioned in the constitution, but it is mentioned in the law, and it is filed against the concerned organization, not on the government. It is not a complaint, it is a request for the information. The fourth objective is the information that have been exempted. There are certain areas where the information is not going to be provided. The first one is information concerning the sovereignty and integrity of India, the security, strategic, scientific or economic interests of the state, because these all are the sensitive information. Secondly, any information which has been forbidden to be published by any court of law or tribunal because of its disclosure resulting into contempt of law or the court. Thirdly, any information that cause breach of privilege of the parliament or the state legislature. Fourthly, the information including commercial confidence, trade secrets or intellectual property rights. Fifth is the information received in the confidence from the foreign government. Next is the information relating to the disclosure of identity which would endanger life and physical safety of any person who has provided information or assistance to enforcement or security agencies. Next is the information which would impede the process of investigation or an apprehension or prosecution of offenders. And the last one is cabinet papers. They are making some decisions for future also, that's why they are not going to disclose any secret, or we can say there is no right to get the information about the cabinet papers. The next feature is the Information Commission. Now we should understand what is the composition of the Information Commission. The Information Commission consists of the Chief Information Commissioner and such number of Information Commissioner that not exceed 10 and appointed by the President in Central Information Commission and by the Governor in the State Information Commission. The President appoints the members of the Information Commission on the recommendation of the committee consists of first the Prime Minister, then the leader of opposition in the Lok Sabha, and the last is the Union Cabinet Minister nominated by the Prime Minister. Now let us understand the conditions of the service of Information Commissioners. Before the year 2005 till 2019, the term of 5 years or until the age of 65 years was the Information Commissioner's age of work. Which one come earlier? And even the State Information Commissioner, the term of 5 years or until the age of 62 years, whichever is earlier. Now after the year 2019, there was an amendment to the RTI and the provision is changed. Now it is going to be decided by the central government. Secondly, once an individual retires from the Information Commission, he or she shall not be eligible for any further employment under the Government of India or Government of State. Now it is also going to be decided by the central government. Now with this we can understand one thing, and that is the power will be in hands of central. So the autonomy of this body is now compromised. It is anti-federal or unfederal because the directions given by the central government. Now the next feature is the removal of the members of the Information Commission. Now what is the ground? It is the misbehavior and incapacity and going to be removed by the President on the reference made to the Supreme Court. It is the Supreme Court rules that misbehavior or incapacity has been established. We can understand this in this way also, that the Information Commissioner, including the Chief Information Commissioner, shall be removed by the President on the grounds of proved misbehavior or incapacity. The President shall refer the case of misbehavior or incapacity to the Supreme Court, and if the Supreme Court upholds or establishes the occurrence of misbehavior or incapacity, the President shall remove such commissioner. By this, I am going to conclude my video. Thank you.